Assalamualaikum warahmatullahi wabarakatuh. I'm Muhammad Adam. In this video, my group and I are going to present about our case Sri Damansara Sendirian Berhad versus Vun Kuan Chien and Anor. First is the legal issue. The legal issue of this case is the breach of contract by the appellant in failing to give the respondent the promised condominium unit on time and the remedies that are available to the parties involved. The case involved an act of negotiation between both parties and interpretation of clauses under Section 84 of the Legal Profession Act 1976, Housing Development Regulation 1989, and Housing Development Act 1966. There are some primary legal principles or statutes that are relevant to this case, which are Section 84 of the Legal Profession Act 1976, which advocates and solicitors acting for developers not to act for purchases in housing development. Second is the principle of fundamental breach of contract, which is the Sale and Purchase Agreement (SPA). And lastly is the principle of liquidated damage. Next is the fact of the case. The developer Sri Damansara Sendirian Berhad, which is the appellant in this case, had entered into a sale and purchase agreement with the first respondent, which is the purchaser for the sale of the condominium unit. On 6th of January 2012, the developer took an amount of 10,000 ringgit Malaysia of booking fee from the purchaser as part of the 10% deposit of the purchase price. On 28th of June 2012, the developer gave back the purchaser a credit note for the balance of 10% deposit payable, which amount is 63,108 ringgit, which appeared to be an act of negotiation as a discounted purchase price instead of the original deposit of 10,000 ringgit Malaysia. However, that discounted purchase price transferred to the purchaser's account was offset against the sinking fund, disbursement for electricity and water deposits, and other monies due under the SPA upon vacant possession. Later, the purchaser filed a claim for the late delivery damages along with the second respondent, Tribunal for Home Buyer Claims, which known as the Tribunal. A little fact about the Home Buyers Tribunal. The Home Buyers Tribunal, or formerly known as the Tribunal for Home Buyers Claim, was established in 2002 by the government as an easier, cheaper and quicker avenue for home buyers to obtain damages or compensation from the housing developers. The Home Buyers Tribunal commonly deals with claims that are relating to the defective workmanship, defective materials, property not constructed in accordance to the approved plans, late delivery of vacant possession of the property, late delivery of common facilities, payment of liquidated and associated damages claim late, refund of deposits and refund of the late interest charges. The purchaser calculated the damages from the date of 6 January 2012, which is the date of the SPA, the date of the payment of the booking fee. However, the developer replied stating that there was nothing suspicious, mentioning that the vacant possession of the unit already given on time from the date of the SPA, which was the 28th of June 2012. Thus, they were not liable to pay for any late delivery damages. The purchaser also filed another claim that stating the actual purchase price of the unit was actually lower than the stated earlier in the SPA. The tribunal sided with the purchaser about the proper date of the SPA, which was taken as the date of the payment of the booking fee, which is the 6th January 2012, and also about the purchase price mentioned in the agreement of SPA.
The decision of court involved two courts, which is the High Court and also the Court of Appeal. The High Court denied the developer's request for judicial review in the matter of Sri Damansara Sendirian Berhad versus Vun Kuan Chien and Anor. This is because, based on High Court, The sale and purchase agreement (SPA) date shall be taken into account as the date the booking fee was paid for determining the duration of the delay for the purposes of a delayed delivery claim. The purposes of computing damages for late delivery, the purchase price specified in the SPA should be considered to the actual purchase price and that it was lawful to pay a deposit equal to less than 10% of the purchase price prior to signing the SPA.
Hi and Assalamualaikum. My name is Nur Adriana and I'll be explaining about the decision of Court of Appeal for this case. The Court of Appeal held that the developer failed to comply with the Housing Developers Control and Licensing Act 1966, which also known as HDA, and the Housing Developers Regulations 1989, also known as HDR, specifically Sub-Regulation 11.2 on the prohibition against the collection of the booking fee. On this case, there are two issues that can be seen. First, whether the late delivery claim ought to be calculated from the expiry of 42 months from the date of the sale and purchase agreement of 28 June 2012 until date of delivery of vacant possession, which also known as VP. Second, whether the purchase price for the calculation of the late delivery claim should be based on the price as stated in the sale and purchase agreement or the reduced price via the device of a credit note issued by the developer. Now for the first issue. The appeal dismissed with the cause. Court stated that Regulation 11.2 of the HDR is very clear on the prohibition of collection of any prior payment before the signing of the SPA, unless there is a prescription under the sales contract. It is irrelevant that the purchase consented to it as the HDA and HDR are there to protect the purchaser. Allowing the collection of the booking fee before the signing of the SPA would be repugnant to the whole purpose of the HDA and HDR. Therefore, the court had no problem calculating the late delivery claim from the expiry of the period of completion from the date the booking fee was paid and not from the date of the SPA. Continuing with the issue number 2, the court held that nothing wrong with the reasoning of the High Court in affirming the tribunal's award in calculating the late delivery claim based on the purchase price as stated and disclosed in the SPA. The court is of the opinion that there would have been no need for a credit note to be issued if the purchase price had been discounted. The credit note was such that the purchase price remained the same, but the purchaser had paid the balance of the 10% deposit from the said booking fee and the credit note. This is a practice to take advantage of the vulnerable position of the purchaser when really it does not benefit the purchaser when the SPA date is not taken to mean the date of the booking fee is paid but a much later date when the SPA is signed. So, on the decision of the appeal court in Sri Damansara's case, there would appear to be some inconsistency in the rationale for deciding that the calculation of delivery of VP is to commence from the payment of the booking fee. The court was of the view that the HDA is considered a social legislation and that the collection of the booking fees is strictly prohibited. It is to protect a purchaser who is in a more vulnerable position due to the inequality of bargaining powers against the housing developers. On the other side, the court seemed to allow the purchaser's claim for late delivery of VP to commence from the booking date by the fact that the 10% purchaser price had in fact been paid by the purchaser even prior to the execution of the SPA. This is supported by the rejection of the credit note discount argument by the developer on the reduction of the purchase price. The decision of the Court of Appeal is interesting because the court quoted that the collection of any booking fee or deposit from the purchaser is repugnant of the HDA and HDR and yet still give legal force to the date of the booking fee and calculated LAD from such date. That's all from me. Thank you.
Here are the conclusion of the case. Sri Damansara Sundarai Berhad versus Boon Kuan Chen and Anwar. So, what can we conclude? The court's conclusion in this instance was favorable because the appellant collected the booking fees against the statutory ban, as the major objective of the law is to promote the balance of negotiating power between the customer and seller. It is required for the appellant to comply with the provision established by the HDA and HDR. Next, the appellant did not comply with the limitation on collecting the booking money prior to the SPA. Regardless, the evident objective of both HDA and HDR is to balance the appellant's natural advantage in negotiating power. As a result, in order to comply with the intent of the aforementioned laws, it is justified for the late delivery claim to be calculated from the expiry of the completion period from the date the booking fee was paid. So similarly, whereas sub-regulation 11.2 of the HDR expressly bans the collecting of any prior payment prior to the signing of the SPA. The collection of the booking fee does occur because the collecting of booking fee is typically documented by a booking form. It resembles a booking pro forma. Lastly, the HDA is a social legislation and the judiciary should consider the protection of home buyers. It will only be appropriate to arrest such behavior by developers and consider the date of collection of the booking fee as the date of the SPA, as the SPA would have been formed when the booking fee was collected. As a result, Sri Damansara should be welcomed as a court of appeal ruling that implemented homebuyer protection in an HDA and HDR specified from SPA environment.
In the case of Sri Dramansara Siddhamberhat versus Wun Kuan Chin and Erna provides several important lessons. Firstly, it highlights the importance of adhering to legal procedures and requirements, particularly in the context of housing development and property transaction. The emphasis on adherence to legal procedures underscores the importance of complying with legal requirements, especially in the realm of housing development and property transactions. This highlights the significance of following the housing development contour and listen at 1966 and its society regulations. By adhering to these legal procedures, the aim is to ensure the protection of buyers and to uphold the proper conduct of property developers. This serves to maintain the integrity of property transactions and to safeguard the interests of all parties involved, thereby promoting transparency, fairness, and accountability within the house development sector. Secondly, this case highlights the principles of judicial review, which is the process by which a court reviews the decisions made by a lower tribunal or administrative body. The case underscores the ground on which its decision can be challenged, such as illegality and irrationality, which permit the court to scrutinize decision not only for the process but also for substance. This means that a tribunal does not have a license to commit an error of law where a question of the right and proper interpretation of a contractual clause in an agreement is concerned. The case also emphasizes the role of the court in scrutinizing decisions for both procedural and substantive issues, which ensures that the decisions made by tribunals are fair, just, and in accordance with the law. Lastly, the application of the doctrine of precedent and stare decisis is demonstrated, emphasizing the importance of prior decisions in guiding and shaping future legal interpretations and decisions. Stare decisis, which means To stand by things decide is a fundamental principle in the common law legal system. This principle dictates that lower courts must adhere to the legal principles established by higher courts in early case when similar circumstances arise. The case underscores the role of established legal principles and the need for the consistency and predictability in the law. By following precedent and standardizes, the legal system can maintain stability, ensure uniformity in legal decisions, and provide guidance guidance for future cases. This adherence to precedent helps to uphold the integrity of the legal system and ensure that similar cases are treated consistently over time. Thanks, that's all from us, Group 6.